That is a lot. So I have a very small prayer, what happened, on 11/4, last day of court, your lordship was pleased to grant me interim bail. With the direction that I will be appearing before the IO within 7 days. So this certificate copy, I could not obtain the certificate because the order was not uploaded. Yes, I filed an IE yesterday. Can you be listed tomorrow?
Addition of it.
Why you couldn't elucidate the petition? I asked my authority to uploaded all the orders because
Even
from
today,
12th,
even
it
today
was holiday. Even today,
Yes, he had complete checks.
it's uploaded. On when, which date?
TD is fixed on 25th.
No. Uploaded petition is uploaded. Why? Who's ordering? How it can be? I just specially I ordered both the all my private secretaries. That's why I just asked them that all orders should be uploaded because from 12 onwards it will not be there. Okay, it will be tomorrow.
My lord, I beg to mention item number 2, my lord. Addition. Addition affidavit filed yesterday, my lord. Item number 2. Kindly come with record.
Yesterday you have filed.
Yesterday.
Okay.
Okay.
Item number 2.
Two.
So it will be for time being only.
For time being.
May I please, your lordship? I have got 4 matters, lordship, before this court today, lordship. All are charge sheeted, lordship, NDBS case, lordship. Now, lordship, thing is that I want to file additional affidavit on notice 50, lordship, section 50. The 2 cases, lordship, out of 4, I have got notice in my hand, lordship, certified copy. Today itself, I will file the additional affidavit, and rest of the 2, lordship, may come up next week any day, lordship.
Which are the numbers?
Number item 5, 9, 10, 11, lordship.
9, 10, 11.
The 9 may come up, lordship, this week, lordship, any date, lordship. 9 and 11, lordship.
9 and 11.
11 may come up for Thursday or Friday, and rest, lordship, 5 and 10 may come up next week, lordship. Because the certificate copy is awaited, lordship. I have not received one.
So you want to fix it on 5 and 9 on next week?
5 and 9, or 9 on next week, lordship. No, 5 and 10, 10, lordship.
5 and 10 on next week?
Next week, lordship.
5 and 10 next week, radio.
Next week.
Next week. Next week.
And 9 and 11, lordship, any date this week, lordship.
9 and 11, any date next week.
This week.
And
lordship.
24th? 24th or
24.
24 today. Oh, no. Next week. He is asking for next week. Asking for next week. 24th will be this week only.
25 also do 24, 30 or 25. Any date, lordship.
No, next week we'll see. All right, fix.
130, 30.
3030.
Item 9 and 11, lordship.
9 and 11 are 30.
30, lordship. Can it be on 24 or 25, lordship, if possible? It's already in my hand, lordship. Today itself I'll file, lordship.
Well, then she said the 24 can be okay.
24, lordship.
Okay, 24.
Lordship.
9 and 11, 24. Huh? List on 24. Or you do next week.
Much obliged, your lordship. Much obliged.
May I please, your lordship? My lord, item number
5
3.
and 11, 5 and 10 next week. Huh?
May I please, your lordship? Item number 27, my lord, on my lord, being my lord, special PP wildlife, my lord.
Yes.
So, my lord, offense report call for my lord received today morning itself, my lord. So kindly little
Sometime.
information, my lord, kindly fix on my lord Friday or my lord next Monday, my lord. With the consent of my other segment.
Mr. Royce.
Yes, your lordship, CD has received. My interim prayer may be considered, your lordship.
No, Friday he's taking, today is Tuesday on.
Yes, my lord. Yes.
Friday, you're saying Friday or?
Friday or Monday, next Monday.
Let it be on Friday then.
Friday, my lord.
I'm doing it.
Just 3 days. your lord.
Apprehending arrest, your lordship.
Yes, just 3 days.
Allowed.
List on Friday. Put it. List on Friday. is which
25.
week? 25. 25.
27.
Yes,
27.
27.
Only 27. Only 27.
Obliged.
At least interim may be considered.
No, for 3 days you will be there looking after the case till Wednesday, Thursday, Friday.
My lord.
2 days are there,
it is,
Wednesday and
70
Thursday.
pages, my lord. So I have some, my lord.
Yes.
I believe the lordship. See, with the concept of the other side, I beg to mention item number 25, lordship. Can it be after 3 weeks, lordship? It is not
25. It's a AB.
Yes, Lordship.
Where, AB, we have any, 25, 25.
Yes.
Oh. Standing council, etc. But you're looking after this case diary also? No, from where you're saying that CD receipt?
Have not received because standing council is different, no, excise department. Kindly serve to us, Lordship, whether it is other.
Who will serve it? Put back
Yes,
the-
yes, sir.
You are Mr.?
W1 on behalf of Mr. Sharma.
You are Mr. W. Rahman. Or Mr. W. Rahman appearing on behalf of Mr. E. Sharma. And accordingly bid for an adjournment.
So
Also,
there is an interim order, Lordship.
in that context, Mr. MS S.H. Bora, the recent PP submitted that name of the PP Assam is not reflected in the cause list. Full stop. Registry is accordingly directed to reflect the name of BP in the cause list. In the same time, the petitioner side is also directed to serve a copy of the petition to the PP Assam. After 3 weeks, you want
Yes, Lord.
list accordingly after 3 weeks. Okay,
Interim
your
order-
interim was there. Interim be continued till next date of listing.
Hello. Well, item 28, my lord. I am told my CD is not there, my lord. And the informant has also filed an objection, my lord. I will reply to that, my lord. Kindly fix it next date, my lord. Extending the interim order early part.
I'm already informed.
You are for the informant. You have already filed your
My
objection.
lord, today I received, my lord.
And CD is not available.
CD is not there, that's why, my lord.
Otherwise, are you on interim? No,
Interim is there.
you are interim. List, here we go. 6/5 corridor, list on 6/5 till then. Interim be- Huh?
7th of May.
You want 7th of May, 7/5/2025 till next date of listing, interim be extended. CD
Lovely.
you have not received. Issue reminder for CD.
7.
Yes, on 70.
Lovely.
What's the objection maybe?
Pardon?
May it please the lordship. Lordship, item number 44, my lord, in supplementary list. On last occasion, this was directed to be listed for hearing, my lord. CD has also been received, but this has been listed for orders, my lord. Supplementary list item 44.
Hmm.
But amicus has also been against. Lord, my prayer would be, my lord,
It should be in hearing column.
hearing, my lord. My lord, I have filed an IA because, my lord, the name of one of the petitioner was wrong. That's why, my lord, I filed an IA.
You will hear to it.
Yes, my lord. I pray, my lord, it may be taken up as a last matter of regular hearing matter.
Let
Will
us
hear.
see. Let us see. Otherwise, we will hear. Even if it is an order column, you can hear. The matter will be heard, I think. I believe.
Yes, my lord. After regular bail hearing matter, my lord.
Let us see.
Because
if it
there is an
reaches.
order for hearing, my lord, in item
I don't know
44.
if it reaches, it will be heard because lots of matters are there already late. I'm just mark it if it
Okay.
can be possible.
May I please your lordship? But contrary to the other side, I beg to mention item number 20, my lord.
20.
2020. Kindly adjourn for the day, my lord. Please after 2 weeks, my lord.
You are for the respondent or? Otherwise, Mr. Biswas is also there. At the request made by the learned counsel for the petitioner. No, sorry, with the consent of the other side, the learned counsel for the petitioner paid for an adjournment. List the matter after 2 weeks you want. List the matter accordingly after 2 weeks. And then they 2 weeks for the list.
May I please your lordship? Lordship, I beg to mention item number 29, lordship. Lordship, in this matter, CD has not probably received.
CD not received. Are you on interim?
Yes,
there?
lordship, interim may continue.
CD not received. Issue reminder. List. Yes.
On
9th,
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 9th.
9/5. Till then, the interim be extended. Interim.
Obliged, lordship.
May it please your lordship. Lordship, I beg to mention item number 34 of the daily list. Lordship, with the consent from the other side, lordship, let this matter come up on next week, lordship, on 28th April. In the meantime, lordship will be filing an additional affidavit.
34.
Yes, lordship.
The consent of the addressee, the learned counsel for the petitioner, bid for an adjournment. Your additional affidavit stating that he needs some time to file the additional affidavit. Is the matter, you want 28? 20, I don't know. Let us see. 30. 30 corridor, enabling the petitioner side to file their additional affidavit.
There is an interim lordship that we-
Interim was there,
Yes.
interim be continued till next date of listing. Okay. What kind of interim was there?
Lordship, it was, the bail was granted, Lordship, 3 months bail was granted to the petitioner as because he was suffering from some cancer, Lordship, leukemia.
Then I have taken consent with the other side, that is NCB was there.
Yes, Lordship.
Lordship, I mentioned I think 21 and 23, Lordship. Perhaps CD is not received.
21
And 23, Lordship.
23. CD not there,
CD not received, perhaps, Lordship. We are
21
interim-
and 23.
21 and 23.
City not received, Lordship.
we are on
And both the
interim,
matters are you on interim?
Lordship. Yes, Lordship.
Yes, when it can be
Let
fixed.
it be on 13th of May, Lordship.
1-3,
1/3.
13th of May corridor, duita, 21 and 23. Issue reminder. CD not received, issue reminder. Interim be extended till next date of listing. Okay.
All right, Lordship.
Happy, Your Lordship.
Yes.
I'm praying for listing of a criminal revision petition, which was last law listed on 27/6/2024.
Before court number 11.
Much please.
Release item 1.
Please, Your Lordship, this is charge-sheeted case, Lordship. He was arrested on 14/6/2024, Lordship. He had
14?
374 days in custody, Lordship.
When 14/6/24.
14/6/24. While arresting the accused, Lordship, no ground of arrest was mentioned in the notice under section of 50. And on this ground, all the other arrested accused persons have already been granted bail by this honorable court. I have annexed the copy at page 39, Lordship.
I think is okay, but have you annexed the copy of
Yes,
the
Your Lordship, I have annexed
notice?
Page 21, Lordship.
21?
Page 21. No ground was mentioned, Lordship.
Lordship, I'm praying for, calling for the scanned copy of the records because arrest memo is not there, Lordship.
And on this ground, Lordship, very recently, Honorable Apex Court has set aside the arrest and remand order also.
No, that is known to us. That is okay. Now she is saying that we are not annexed the arrest memo. Is there the ground? That's what she is saying. We'll give a short date to call for the, where from it has to call for?
Those, Lordship.
To be, yes, Bora, when it can be, otherwise.
Special NDPS case number 541. Special NDPS case number 541 of the.
Special NDPS 541,
41,
Pending the
541 of 2024.
24.
From Dhubri.
Those,
Special judge Dhubri. Special case, NDPS case number 540. 541, you said,
541, Lordship.
of 2024. Registry will do the needful, all the scan copy of the LCR, along with the case diary, list accordingly. किमान time लगेगा फिर? Otherwise, how to please? 2nd of May will do. 2nd of May.
Lordship. Highly authorized. Item 3.
May I please, Your Lordship? The petitioner is booked under section 21C and 29 of the NDPS Act. And it is a charge sheet matter, Lordship. And the petitioner were arrested on 20/10/2024. Thereafter, the charge has
2010.
been framed, yes, 2010. I have filed this petition on the strength of non-mentioning of the grounds of arrest, Lordship.
Hmm.
And I have annexed the arrest memo, Lordship, which is at page 25.
25.
25. In the arrest memo, Lordship, and there's column 8, 9, and 10, reading as name and address, email ID, and telephone number, whoever to convey the arrest information has been kept blank. Next, name and rank of the officer making the arrest, and in column 10, grounds as reasons of arrest. All three has been kept blank for the reason best known to the prosecution. And following which, your Lordship is well aware of the Prabir Purkaista and Bian Kumar judgment, your Lordship.
Whether the notice of section 50 of the NS Lordship, whether that has been annexed or not.
You have the notice also with you?
No, I have not annexed the notice right now, Lordship. I have only annexed the arrest memo. Lordship, in the Prabir Purkaista judgment, Lordship, it has discussed in para 47 and 48, it has discussed vehemently that even if, may I read the Prabir Purkaista judgment?
Yes,
Lordship?
okay.
Yeah.
No, we need the arrest memo and the 50.
Yes.
50 or say 47, whatever. Do you have any 47 or 50 a certified copy or any copy? If you have 40,
That
then
is something next to have.
that's what I'm saying, because I don't know whether there is any arrest memo. It's not there. You have submitted already. But I don't know whether in 47 or 50 notice, is there any arrest, ground of arrest? Probability, obviously, I also admit that probability may not be there. So that is the other case also the same ground we are calling for a case record. Or otherwise, you could have submit an additional affidavit through that only it can be accepted, if it can be, but you need some time.
Yes.
Then otherwise, from where it has to be called for?
No, Kamrup Metro only.
Kamrup
Yes,
Metro only.
from the session, honorable session. Judge.
30 could be 30. 30.
So can it be 26,
No, not possible.
30, 30? Okay,
30. Call for this scan copy of the LCR along with this scale. 34. In the meantime, you can also get this certified copy, because if any reason
Yes,
if it doesn't reach, then you can make submission also.
And of blood. This is all the supplementary list.
Lord, the petitioner is in custody for 35 days. He is aged about 23, girl is around 21, 22. Both studied together, had a love affair, and when nowadays the love affair, when it goes short, then the affair at page 20. Page 20, my lord, your lordship can, nowadays we have started typing the Assamese affair because the language doesn't change. And this is another way of promoting our own language, my lord. Page 20 is the affair. Your lordship will take note of the date of the affair is 17/3/2025, and the date of incident is 8/3/2024. So after 1 year, my lord, the girl decided to.
Date of incident is 24.
Yes, 8/3/2024, second line. I'll not read the contents, your lordship will read into the contents and.
Yes.
Courts are nowadays flooded with this type of cases, my lord.
Yes. Just tell us only one thing, whether his mobile, etc., are already been seized in connection with this case?
Fully interrogated in custody for last I'll check the total number. 35 days in custody. So further custodial detention.
Annexed the seizure list also here?
No, they have not furnished us any seizure list because forwarding report is there. Forwarding report is there. Forwarding report is at page 27. Your lordship look into the grounds of arrest. 27. Is an affair named accused, available evidence found against the accused person, which is a normal line. The accused person in the honorable court, wherever required, cannot be ensured. If not arrested, he may tamper evidence, manipulate the witness, or he may again involve this. He is not.
Yes.
Admittedly, the date of occurrence is on 8/3/2024. And the photographs, options photographs has been taken on 10/3/2025. But that has been transmitted in the social media on 10/3/2025. And thereafter, Lordship, FIR has been lost. So at this stage, I'm praying for the case diary.
Student, my lord, and interrogation is complete, my lord.
That means those videos were uploaded on 10/3.
10/3, Lordship. Thereafter, Lordship, on 17/3, FIR has been lost. So that's why I'm just praying for a shortly, Lordship. It's from Kamrup Metro. CD is requirements.
Friday মানে পাইবেন
Friday.
Okay.
Friday, ইমান জলদি নহব দাদা অকণমান দিয়ক সময় সেকেন্ডত লৈ লওক
জালুকবাৰী
ফাৰ্ষ্টত লৈ লওক
How?
on 1st of May.
Student only, that's why in cases where student only I pray for short date, otherwise not. Others they can relax.
Relaxed, they can stay there.
But problem is, my lord, why I'm saying in most of the cases where I appear for the student, I say because jail is not a place for the student. It's now have become a criminal production center. There they will come with all the persons who are history seekers. New ideas will be inserted into their brain. So that's why in case of student, first time offender where there is no criminal antecedent, your lordship may consider. But she wants a short date.
29th, Lordship.
29. 20.
More shorter, 29.
Lordship.
30.
Lordship.
30. City call for COVID 30. Okay, we're calling for the case.
Bless.
Item 4.
Please, your lordship.
Yes.
This is a 482. My lord, your lordship has already been rejected in this case, my lord. Earlier.
Earlier.
So case diary may be called for
If earlier rejected, then case
up
diary.
to date civil law.
Okay. Updated case diary be called for. List accordingly when it can be listed.
To Buri.
I do not make one alone.
Oh, yeah, I can.
On 9th of May.
9th of May.
Yes.
Hello, bless.
37.
My lord, here in this case, my lord, I have very limited prayer, my lord, for transit bail, my lord, for 3 or 4 weeks, my lord, because what happened, my lord, in this case, my lord. First, my lord, summon was issued against the petitioners from the CN police station, Bangalore, my lord, under section 94 and 179, my lord. And after receiving that summon, my lord, the petitioners given reply to that summon, my lord, through registered post, my lord. Thereafter, again, the IO, my lord, sent 35(3) notice, my lord, BNSS, my lord, under BNSS Act, my lord, and asked them to appear within 7 days, my lord. So they are from Assam, my lord, from Kamrup rural, my lord, district, my lord. So they, my only prayer, my lord, they will go there, my lord, and collect the certified copy and file proper bail application there in the Karnataka High Court, my lord. Till that period, my lord, 3 or 4 weeks, my lord, your lordship may kindly protected, my lord, of transit bail, my lord. That's my prayer, my lord. Now, my lord, your lordship may kindly see the notice.
This one is, this petition was earlier also filed or this is the first time?
First time. First time.
I don't think so, Lordship.
Page 12.
Page 12.
Page 12, the notice.
11.
Just came up. Not rejected or filed, not filed.
It was came
Just
up
came
on
up.
11/4.
First date, my lord, it was came up on 11, my lord. They took time, my lord, that to see the legal provision, my lord, whether transit bail, my lord, can be, there is any provision, my lord. So I have collected two judgment, my lord, one of Apex Court Division Bench judgment, my lord, and
No, it
one
was
of our High Court,
Before Justice Goswami on 11.
my lord. Yes,
On
my lord.
11/4 it was Justice Goswami.
Mr. Goswami, my lord. Honorable Justice Goswami. So they took time to see the legal provision, whether, because the person is from here, my lord, and the case is registered at Bangalore, my lord. They have noticed to appear before the IO, my lord. So they took time. Now, my lord, I have collected two judgment, my lord. One is, my lord, our High Court.
First notice, when you have reached your first notice?
First notice, my, there are two petitioners, my lord. Your lordship, page, first notice, page 12, my lord. They issued on 12/3, my lord. The petitioner received on 26/3, my lord. It was summoned, my lord, under section 94 and 179, my lord, of BNSS, my lord.
Hmm.
And thereafter, again, they gave a reply, my lord, of that notice, my lord, first notice, my lord. Thereafter, they have sent, my lord, second notice, page 13, my lord. That is under section 35(3) of BNSS, my lord. It was sent on, my lord, 22(3), he was received on, my lord, 4(4).
But it was sent only on under section 94.
First one, 94, my lord.
Then subsequent
Then
one
subsequent one, my lord, page 13, my lord. It was 35(3), my lord, BNSS, my lord.
for the same person or whom?
Same person, my lord. Two petitioners there.
Two petitioners.
Two petitioners.
For two petitioners, name are there.
No, my lord. It is another one, notice is page 14, my lord. I have annexed separately, my lord.
14.
14, page 14, my lord. The similar, my lord. First notice was 90, under section 94 and 179 of BNSS, and second page 15, my lord. That is under section 35(3) of BNSS.
Oh, so otherwise, what is the case about?
Case is, my lord, basically the allegation section here mentioned, my lord, 66 and 66D of IT Act, my lord. That is bailable, my lord. 3 years, after 3 years punishment, my lord. 66C is, my lord, theft of identity, my lord, identity theft, my lord. And 66D is, my lord, cheating by personation, my lord. Here, my lord, only non-bailable section is 3184, my lord. Subsection 4, my lord. That is, my lord, cheating, my lord. It is up to 7 years, my lord. It's non-bailable one. I have annexed the, my lord, reply also, my lord, after received the first notice, my lord. That is page 16, my lord. I annexed the bank statement also, my lord, for last 6 months, my lord, of both the petitioners, my lord.
Copy of FIR also you have annexed here.
Yes, FIR I could not find, my lord, because I have to go there, my lord, and to collect the certified copy and to file proper application there in the jurisdictional court, my lord. Till that period, my lord, 3 weeks, my lord, so that he cannot be arrested on en route, my lord, he cannot be arrested, my lord. Therefore, that immediate purpose, my lord, transit bail, my lord. I have annexed one order also, my lord, of our High Court, my lord. That is on page 52, my lord. 52, my lord. And my lord, I have given, my lord, one of reported from our High Court, my lord, GLT reported, my lord, and one of Apex Court, my lord, recently, my lord, 2023, 0 SSC 1164, my lord, Dingman judgment, my lord. Para I have mentioned, my lord. So, my lord, for 3 weeks, my lord, there are 4 people, my lord, petty businessmen, my lord. I have annexed the bank statement also, my lord. I am not on merit, my lord. I just I want to go there, my lord, to collect the certified copy and file proper bail application, and that will be decided by the court on merit, my lord. But from here to go to Bangalore, my lord, till that period, my lord, for 3 weeks, my lord, they may be protected, my lord. For transit bail, my lord. That is my prayer, my lord.
Yes, but I'm.
Lordship, what is the allegations against a petitioner? That is not before us,
That will not
first
be
of
for
all. So at this stage, it is difficult for us to say, give our opinion.
318 subsection 4 is the what section cheating? I think 318 subsection 4 of BNSS.
Cheating, my lord, cheating. That is, my lord, mentioned, my lord, cheating and dishonestly, my lord, inducing the delivery of property, my lord. That is 7 years, my lord. All are below 7 years, my lord.
That is 420.
420. Yes, my lord, cheating, my lord. My lord, I have annexed the bank statement also, my lord. Nowadays, my lord, that online fraud is going on, my lord. So maybe some other person, because the first notice, my lord, they say, my lord, there is a 94, my lord, section 94 of BNSS, my lord. It is, my lord, clearly says someone to produce documents or other thing, my lord. And section 179, my lord, police officers power to require attendance of witnesses. They may be witnesses also, my lord. So as they
That's
fail
what
the
I'm saying. Other first notice was under 94.
first are 94.
Subsequently 35(3) was there.
As they
So
failed, my
there
lord.
are some things.
So, my lord,
They have already collected against you. So for that reason, instead of 94, subsequently they had to issue
they have
35.
They have the given reply also, my lord. My lord, okay, not
Okay,
on
I'll pass you.
my lord. For limited period, my lord. 2 weeks or 3 weeks.
Here is order. I mean to say.
Obliged, my lord.
Okay. আগতে এটা অর্ডার দিয়া আছে সব নম্বর মিলে মানে সব নম্বর কাউন্টার যাব ভিতর থব পারি ঠিক আছে
For bail hearing, item 6.
Item 6. Item 6. No, none appears on call for the petition. list accordingly after 2 weeks.
7.
Petitioner side is absent on call. Is the matter, no, itu agoto নাই, কোনো নাই। Next to consecutive date of 9, next week করে দিও, last week করে দিও, next week.
I'm on behalf of, I'm Mahadev, it's like another code. I'm at a scale.
Which code, which case?
Number 7.
Item number 7. Okay. Yeah, Mr. Chaudhary, na? D. Bora, sorry. D. Bora appeared on behalf of Mr. M. MSSH Bora করে দিব। Here petitioner side is remaining absent since last 2 days, I think.
Yes.
So one more date we are giving the next week, and if it is they not appear, then it will be dismissed. Okay.
Item 8.
May I please your lordship?
Yes, Mr.
My lord, this is the case where earlier also came before 483 minutes, but I am behind the bar almost 811
Your
days.
name, why your name is not here today?
My lord, my name is not there, my friend's name.
Okay.
My lord, with
Yes.
your lordship permission, my lord. My lord, earlier what happened, my lord? I was granted anticipatory bail because when the offense detected, my lord, the master of the house, my owner of the house,
Okay, status
he was
report we
missing.
have received.
A status, my
As per office note dated 11/4/25,
Ah.
status report not received, Lordship, updated status reports.
Up to date status report be calling for now.
Yes. For office note 11/04/25, that is not.
Why it is saying, is it a charge-sheeted case?
Yes. Main
Oh.
culprit is absconding. I was a maid servant in the house, daily wager. I was caught, my lord. I was initially not caught. Then I approached for the anticipatory bail. Anticipated bail was granted by the Lanet Session Court. But when the charge sheet was filed, I approached before your lordship. Your lordship directed me to go and appear and pay for regular bail. Then, but I am behind the bar since last more than 2 years, my lord.
But most probably it is a case of NDPS. That's why we need this status report. That's what
That's what
calling for.
lordship was kind enough to call for it.
Yes,
has not
it's
come.
not
It
come,
has
it
not
not
come.
come.
Lordship, there is the office note.
No, we have also
And
seen.
otherwise,
Nothing
he
was
also-
recovered from
it's
me.
not that
I was not the owner of the house.
That
It is
not
being
that
admitted that I was
otherwise-
working as a daily wager.
No, then when anticipatory pay for anticipatory bail, then
Was
it
granted by the
charge-sheeted.
Lanet Session Court. But
Oh, it
when
was-
case was charged sheeted against me, then it was cancelled by the Session Court. Then
Session
I
court-
approached before your lordship, my lord. That I was on anticipatory bail, but your lordship also directed me go and appear, pay for regular bail. But it was not considered, I was put behind the bar.
Your foot behind. The next why it is not it? It has to come from which district, in fact?
From Kachar, Silchar.
Silchar Kachar. The Silchar Kachar also can be received because it
Yes,
will
it
be
can be
scan
received.
copy only.
Yes.
It's দিব পাৰি নেকি?
Lordship,
Can it be on 29, 30 or whatever?
30, it's from Kachar, Lordship,
Kachar,
second or third.
second or third. Second, make correction from the office note dated 11/4/2025. It is sent that the status report as called for is not yet received by the registry. Issue reminder, registry will do the needful. No, issue reminder with a direction to the concerned court below to send the
Updated
status report
status
of the present present status report of the case. Post of registry will do the needful in issuing reminder. List the matter accordingly. Second of May list. Sure. Yes, had Mr. S.C. Biswas করে দিব আর registry is ever directed to reflect the name of Mr. S.C. Biswas and in the cause list on the next stage.
Obliged.
Item 12.
May it please your lordship. Lordship, here, I have not been under the ground of arrest.
Pardon? Ground of arrest.
Yes.
Look, it's here amicus is there.
I took him.
What is the status present at this stage?
Service report not received, I think, Lordship, and in the meantime, charge has been filed.
My lord, I am on the
Acha, oh,
notice.
you're on the notice. Have you annexed the notice?
My lord, I have
That's-
applied today, I will get certified.
That's-
Let it
that
be
how
on
can
Friday.
this-
Let it be on Friday, my lord. In the meantime, I will.
Okay, then you apply for, if I have already applied for.
Already
certified
applied,
copy.
today I will get.
Okay, list go ahead. In the meantime, can we appoint one amicus here?
Lordship.
Amicus, I don't know, নাম দিয়ে দেখুন, কার দেবেন।
Decisive title, sir.
কোনটা কোনটা? TRW, Sri TRW. As an amicus, registry will do it. RO. Released accordingly on Friday, 25. Many matters.
Then will 28, my lord.
28 or 29, he's saying 29 or 28, you're saying 28, 20. Doctor.
In the meantime, I will file additional
Yes, sure.
affidavit. I am DP.
30.
Yeah, so we're calling for the scan copy. no?
Yes, Lordship, but perhaps there is
And
the
if it is
office. note,
received
Lordship.
or no, no,
If not received, perhaps there is the office note.
received. Received, I think office note is there.
Has not been.
None appears on call for the petitioner. Scan copy of the LCR, scan copy of the LCR along with the status report is also not received. As reflected, as revealed from the office note dated 11/4/2025. List the matter accordingly after 1 week. Registry will do the needful query. 1 week. Yes, ma'am.
Kindly pass over the matter for timely motions. Excellent.
14. Okay.
15.
Not received a case dry, Lordship.
We are calling for the FSL along with the case date has not been received. Your petitioner is behind the bar since when is it a charge sheeted? Not charge sheeted.
Not charge sheeted. Since 158 days as of today.
158 days. Commercial, no, 158 only. When it can be given, the Kusami?
Lordship. 8 of May, Lordship, 8 May. 158 today.
8 May to boarding house of 1 week. 8 May, no? Ajay?
Today is 22nd. 16 days. In 20 days, it is 178.
In 20 days?
And when 8 May, Lordship, it will be
178 days.
174 days.
This should reminder 8 May. Correct. Okay. See that, please. 8 May. 8 is Saturday. Hey, 8 is Saturday.
8 Saturday. 8 May, no, Thursday.
8-5.
8-5.
See?
My lord, the office note says scan copy and status report that has not been received. But my
Not yet
lord,
received. Not
not
received.
received.
Okay.
But the petitioner is behind the bar since 2 years, 4 months, my lord. And the co-accused, my lord, he has been released on bail before 1 year, 4 months back. Last
No,
occasion,
ground of parity cannot be there, but the question is there any ground, what's ground you are taking? Only ground of parity you want to place the
Parity as well as, my lord, detention, period of detention.
No, that's what I'm saying. Detention is there, but what is the status of case? We do not know at
My
this
lord,
stage. That is why.
That short date may be fixed, but it scan copy only, my lord.
Scan copy, definitely. From where it has to come?
Gwalpara.
From Golpada. Yes, Goswami, when it can be given?
It's from the state of sales. And first week of May.
First week of May will do.
My lord, on 28 or 29, my lord.
29.
See?
Okay, then 29 we are fixing.
Obliged.
From the office note dated 11/4/2025, it is seen that the scan copy of the SCR along with the case diary is not received by the registry. Issue reminder. This is the matter accordingly on the 29/4/2025. Registry will do it in file. Okay.
Obliged.
17.
May I please?
Thanks.
Well, this petitioner arrested on 22/4/2025. 21/1/25, my lord.
21. 21.
22/1/25. 91 days in custody today. The only point is, my lord, that same point, my lord, 47 and 48 will not be served to us.
You have already annexed the copies also.
Not been served.
Not been
even
served.
Not been served.
Yes.
Only arrest, my lord.
Whether it was a shown arrest matter or what?
No, only arrest memo has been given, nothing. No 47, no 40.
What is the position you have received any?
Case diary here.
Received. Okay.
Arrest memo here and 47 notice there.
47 notice is there or not?
Yeah, okay.
There is there. Okay. 47 was there, but it was not served. You're saying that it was not served.
Good one. Our throat is on.
Signature as an sound. Show Mr. Border.
Ground zone is there, no ground zone.
That was not there.
In the notice as well as in the arrest memo.
Arrest memo.
Grounds of arrest are not there.
Grounds of not there. But I want to point it out one thing also.
Yes.
The note of iOS noted here.
Hmm.
গ্ৰেপ্তাৰৰ কাৰণ arrest member 47 BNFS যোগে জনাই দিয়াৰ লগে তেওঁ অভিভাৱক 48 BNFS জনাই দিয়া হ'ল। But in the case there, that is not in there.
Man, it is through verbal there was any communication or what? Huh?
They have stated that part of IO note what's it. গ্ৰেপ্তাৰৰ কাৰণ arrest member 47 BNFS যোগে জনাই দিয়াৰ লগতে তেওঁৰ অভিভাৱকক 48 BNFS যোগে জনাই দিয়া হৈছে। As per their note. Means
48 is not in
48
there.
on the case diary.
48 is not there and the 47 grounds of the arrest is not there.
Why they are saying that ground of arrest an idea whole?
If there is anything that we have to take instruction from the IO then.
No, this CD is already available. I think there's not any written form. There is nothing. Verbal may be there. I won't say that's not there, but otherwise also it is an admitted fact that he knows why he has been arrested. The person. Otherwise, if you see, he was arrested.
That's a different issue, my lord.
That's a different issue. But the question written is not there.
Written is required. That's the law.
Otherwise, recovery is made from the petitioner.
Same recovery. And as per you, recovery was there from you?
Recovery, actually not from me. There are few, they have fled away. I was bystander, my lord. They have got named in a part. Probably one bike they have recovered from one bike.
A conscious person, I believe you. 47 arrest memo was not there. It was a main ground. Promoted recovery is direct from the position of the conscious position of the petition. For whose satisfaction it has to be there?
My lord, this will be. Salmara. Yeah.
Not teachers. Not teachers. Here to ground point to animal. Still under investigation.
He was produced at my lord South
South
Salmara,
Salmana in a sense.
Mankacha.
That's into it.
Especially the same.
Forwarding, you see, that's forwarding.
Forwarding, it was forwarded in CGM, my lord.
TGM. Okay.
Special judge, my lord, South Salmara.
South Salmara, yes. Special judge South Salmara. Special judge South Salmara. Okay.
All right.
Assisted by Quinton Naam to do B, no? B. No, B. Yes.
18.
That, please, your lordship.
Yes.
You have received the case there.
Section 21 Clause B of NDPS Act, your lordship, total 44 days in custody, your lordship.
Total 44 days.
Your lordship. 3 accused person were arrested, your lordship, on 9 March, your lordship. All are resident of same village and cousin brothers, your lordship. And a list 7.15 gram heroin recovered, your lordship.
How, what is the quantity? 50?
7.15 gram. As per FIR, your lordship, is number 12.
7 point.
57.15. 57. And 5 gram to 250 gram. Under 21.
Yes, it's intermediate.
Intermediate.
I received the case there, but FSL report not received there. Otherwise, total materials are there. They are, as per their statement, they are working as a mystery, poker mystery. But to earn easy money, they are selling and doing business of drugs. They are here as their statement.
Custodial, your lordship.
So 44 days, your lordship.
Kindly,
Wait for some time.
further custody may not be necessary, your lordship. 44 days already, your lordship. Kindly allow, your lordship. A special report may not be necessary, your lordship, up to 250 gram, your lordship. Only 57 gram as per FIR report.
What to do? They are the peddler also, no? Yes, for some otherwise 44 days can be
44 days,
considered.
lordship, wait for some days. We have to wait for the FSL, lordship. After that, lordship will consider us.
Further study may not be necessary. 44 days already they are day laborer actually. Come from Sor area, Mazir name, your lordship.
Maybe, lordship, but they are not a gentleman, lordship.
But 44 days is custodial, your lordship. BA, lordship. Only 57 gram. Up to 250 gram, your lordship, is the intermediate quantity. Kindly allow, your lordship.
For earning easy money, they are selling drugs. The youth, lordship.
So it's a custodial.
If
according
lordship goes to
to
their
your lordship.
statements, lordship will never consider this.
The length of
So
defeat.
wait for some time, lordship. After, if in the meantime, FSL receive, lordship, mandatory period will be there, lordship.
FSL.
So fix
Then
on
can
the,
it be calling for the updated one or
Lordship.
can it be disputed? The updated one. City return query, updated CTP call for along with the FSL report. List accordingly, yes. 19 days, after 19 days, you can.
2 days, 29, 4.
20.
Oblige, lordship.
19.
And in this case, also all systems are procedures are followed. Grounds of health 47, 48.
May I please, your lordship. In this case, lordship, the petition.
Your one BA is also there, one BA 3445. Ah, yes.
Yes, that has been disposed of, lordship.
Yes, you have to tag with this one again.
Yes, lordship.
3445.
Bail to the co-accused persons was granted, Lordship.
This by this order.
Yes, Lordship, by that order.
So can it be before appropriate bench then?
Lord,
It was
that
by
court is
Justice
not
Kalita, I
available,
think.
Lordship.
Huh?
That court is not available today, Lordship. Lordship may take up the matter. Honorable Justice.
Mr. Kalita.
Yes, Lordship.
Kalita is available, I think.
Today he is not available. Today is taking
Today he is not available.
not available.
He's on leave or what?
There is a notification, Lordship. List was there, Lordship.
He is on leave, I think.
As per notification. But Lordship, as per notification, Lordship can take up the matter. Even Lordship, as per the recent judgment of the Honorable Apex Court, Lordship, on the basis of which this notification has been issued, Lordship may take up the matter. And Lordship, that was not rejected, in fact, Lordship. Bail application was allowed, Lordship. So it is not a case of rejection.
That's why I'm saying opinion may differ. That's why I'm saying.
Yes.
Opinion may differ also. That's why I'm saying.
Lordship, I'm taking the ground of Lordship, non-furnishing of ground of arrest, Lordship. Page
But
number.
ground of arrest is not there.
Scan copy of the document, not there. Lordship, I have annexed, Lordship, in my petition. Lordship may kindly take up my petition, page number 78.
Page number 78.
Yes, Lordship. Item number 19, page number 78.
Then why it is tagged with this one? Because
As
we have
because-
already.
Yes, Lordship, as because, Lordship, in the earlier case, records were called for. Just to have those record, Lordship, as because both the cases are out of the same FIR, for the records only, Lordship.
Otherwise, you have annexed the
Yes,
notice.
yes, Lordship, yes, Lordship. I have annexed the wrong notice, arrest memo. Lordship.
Arrest memo.
Yes, Lordship, page number 78. Name of the petitioner, Mahbub Hassan. No ground of arrest. Now, Lordship may kindly come to next page. Page number 79. This is the arrest memo. Yes, Lordship. And Lordship.
What is your name of your petitioner?
Mahbub Hassan, Lordship.
Mahbub Hassan.
Hussain. Mahbub Hussain. Here also, Lordship, I have flat mark, Lordship.
So since when you are in custody?
Since Lordship 6/2/2024.
6/2/2024.
Was a co-driver, Lordship. Charge sheet was submitted, cognizance was taken, Lordship. Charge also have been already been framed. Lordship.
Charge framed?
Yes, Lordship, 18/1/2025.
18/1.
Yes, Lordship, 2025.
25.
25.
Till date, no witnesses examined. So you are basically on the grounds of
Yes,
arrest
Lordship.
and. Okay. And otherwise recovery is from you or
From the other person, Lordship, who has been granted bail.
already granted bail?
I was also there, Lordship, in the car, Lordship, as a co-pilot, Lordship.
Conscious person liability. If I do a commercial quantity, conscious person. Same for submission. Board. Okay.
Highly
To
obliged.
satisfaction, this one.
Special Judge Shribhumi, Lordship.
Special just
Highly obliged.
Thirty-eight of the supply list.
For 38 application, Lordship.
Yes.
My name does not reflect in the FIR or any other document, Lordship. And Dr. Wen has been recovered from the position of another accused person, that is Manoj Dehiya. She will find that. Alexa B, it is at page 18. Lordship.
This is the Caesar list.
Caesar list. That's from Manoj Dehiya, who has already gets regular bail.
Yes,
It's
madam.
still under investigation.
They received, my lord. Yes, my lord. From the initially, my 2 persons were arrested, my lord. Initially, Manoj Dehinga, from whose possession, my lord, those contrabands were recovered. Thereafter, one another accused person, Tupul Dotto, was also arrested on 5/3/25. Now the police is in search of the present petitioner, my lord. He is absconding. And my lord, both the accused person stated that, my lord, the name of the present petitioner, my lord, that he is also involved along with one Tupul Dotto and the present petitioner. They actually, my lord, stopped all those contrabands in the residence of the Manoj Dehinga. And my lord, thereafter, my lord, from the residence of the Manoj Dehinga, those contrabands were recovered by police. On 27/2/25, Manoj Dehinga was arrested. And there,
Manoj Ding and Ripple Dr. bail copies are there also.
yes, but my lord, the present petitioner is not yet arrested. This is anticipatory bail.
So as per the thing, they used to stop all these in place of Manoj Dehinga. So these are the orders of the other two petitions, other two accused persons. Ground of parity cannot be taken as a ground because these two are given considering, in fact, considering the length of detention.
Yes.
In the other two matters,
Yes, sir.
but your petitioners, I don't know, he is not in custody, so you are seeking for the anticipatory.
But the statement of the co-accused lordship that cannot be used. Otherwise, there is nothing on record against me.
Yes, still the investigation, I think, cases. There may be materials may come out. Heard Mr. Dr. Vilana counsel for the petitioner and also heard Mr. P. Botaku, Vilana additional PP appearing on behalf of state respondent. This is an application under section so and so in connection with so and so CD received. Very same. It is submitted by Mr. Dr. Vilana counsel for the petitioner that present petitioner is innocent and he is no way involved in the alleged offense. From the Caesar list, also it is seen that the alleged contraband has alleged to have been recovered. All the contraband had allegedly recovered from the position of the co-accused, one Manoj Dehinga and nothing has been seized from the position of the present petitioner. However, the police is searching for the present petitioner and hence he has an apprehension of being arrested in connection with this case. However, the present petitioner is ready and willing to cooperate the IO in further investigation of this case if he is granted with the privilege of pre-arrest bail. Next paragraph. Mr. Botaku, Dilane additional PP submitted in this regard that that the sufficient materials have already been collected by the IO against the present petitioner and he against the present petitioner who is stated to be one of the partner of the other two the persons who already got arrested in connection with this case. And as per the materials collected by the IO, the present petitioner along with one Bipul Doctor or Wood Doctor.
Tupul Dotto.
Tupul Doctor used to store of the contraband in the house of said Manoj Dehinga, the co-accused, and accordingly his custodial interrogation may be required for the for the interest of the proper investigation. Mr. Botaku accordingly raised objection and submitted that it is not at all a fit case to grant the anticipatory bail to the present petition. Next, hearing the submission made by learned counsel for both sides and considering the materials available in the case diary, I do not find it a fit case to extend the privilege of pre-arrest bail to the present petitioner at this stage, who is stated to be the peddler and is seems to be involved in the alleged offense. This present petition stands as posted. Your petition stands rejected.
Okay, Lordship. I will let-
39.
Yeah, please, Your Lordship. For it to be application, there is 23-1, I know it's around 89, 90 days, Your Lordship.
Arrested on
23-1, 2025.
23-1.
No, most around it's 90 days on as of date, as of today, Your Lordship.
Around 80, how many days? 80?
89 days.
89 days today. Just first of tell us one thing, is there any probability of filing the charge sheet within 2-3 days or within?
My lord, in some, my lord, although CD is available with me, only my lord, police has not yet collected the FSL report. Otherwise, my lord, from the statement of the victim, there are my lord, sufficient incriminating materials against the accused. My lord, I will get the answer. Although CD is with house, my lord, in some cases, police, my lord, maybe my lord may file the search sheet, my lord. So I will have to get the answer. Although CD is available with us, my lord. Tomorrow, I will get the instruction. Tomorrow, 90 days will be completed, my lord.
I consider actually on last occasion also since amicus curiae was not there. That's why
Amicus today, she is here.
on the last day because amicus curiae was not there. That's why it was not disposed of. Your Lordship.
No, that I don't know.
On
Service
8th
was completed on
8th of
and
April.
accordingly, Mr. Brown was appointed as an amicus. Now that's what I'm just asking him. Today is 89 days. We are also on that. And
Oh, Your
if
Lordship, section
the IO is still waiting for FSL report, then obviously it may take 2-3 days more time. Or in the meantime, we've already just Botakuri has submitted that. If already suppose charge sheet has already been filed, I don't know. But CD is otherwise with Mr. Botakuri. So the probability of filing a charge sheet is very less otherwise. So let it be on tomorrow, we'll see to it. Let the matter be fixed on tomorrow.
There is no penetration there. So maximum section 8 of Oxford may be attracted, which comes on.
Penetrative assault is not there.
Not there. So
Yeah,
section
you
4
have
is not
anything to say
attracted. Your
in
Lordship.
that context? Have you gone through the record?
But then, Your Lordship, the allegation is grave if Your Lordship goes to the FIR. And also the age gap needs to be considered, Your Lordship. The accused is 44 years and the girl is 16 years old. Your Lordship.
The FI itself it is given. No, section 4 will not be attracted. Your Lordship, what
Your
we have
Lordship,
seen.
trial if it will or not. But then
Maximum
by the,
section
by
8.
the ingredients of the FIR, Your Lordship will see
That
that.
is 60 days is the this thing. Section 8 comes with 60 days, Your Lordship, because 3 to 5 years is the money. That's why, Your Lordship.
Yes, obviously, if penetration is sexual penetrative assault is not there. Then
Section
it
4
may
not
come,
be
but I don't know.
8 may be extracted maximum. Your Lordship. So in that punishment is less. Here. Maybe taken up at 2, Your Lordship. May take the instruction. Be taken up at 2.
Otherwise, my lord, from the victim statements, my lord, and the birth certificate of the victim is also available, my lord, as per.
Otherwise, allegation is very still allegation.
Details is there from 164 statement, and victim is also minor, my lord. Considering that aspect, my lord, your lordship may kindly fix the matter tomorrow. In the meantime, I will get the instruction if my lord till 90 days will also be completed tomorrow, my lord. And
But otherwise, the allegation in the FIR itself is very still allegation. Okay, list tomorrow. Tomorrow, just a second. Tomorrow, I'm only sitting on the first half only. The second half I'm not. Yeah, second half I'm not sitting. Tomorrow, I have some personal. Second half we are not sitting. In fact,
yes.
So tomorrow, let it be on day after tomorrow. Then 25.
Yes.
Or you can, if you take the instruction today, you want.
Yeah, that's what
Then yes, yes, lordship may kindly fix it too.
At 2? Okay,
I will try to
okay,
get
okay.
it.
I'm fixing it. Two PM. 2 PM.
40.
Yes.
My senior, Mr. Enzo, engaged in another court, so the matter may
For
take
time
on
being.
time.
You want to put it timing?
Timing.
41.
In 40, what is the position? Botaku is CD is here? CD already received.
50, 50,
41, yes, 41. 41 is
53 days in custody, madam. Only
41 so CD received. Yes, what you say?
Madam.
Yeah.
Madam, the accused arrested, madam, 01/03/2025, madam. 53 days in custody, madam, till 2 days.
0103 03.
Yes, madam. 25.
53 days, how it comes? 53 days?
March 31 days. And April 22 today.
What's a 01?
Yes, madam, 01.
Acha.
Madam, allegation of recovery of minor, 31.16 grams of heroin, madam. There are 2 persons, madam. And as per allegation, 3 packets of heroin, madam. But not specifically mentioned, madam, from how much has been recovered from whom accused, madam. Affair page 13, madam.
What is the quantum of this, the quantity of this thing?
Yes, madam, 31.16 grams.
31.1.
31.16 gram. From three.
From 2 persons, madam, and
Wait.
3 packets of heroin, madam.
They were together, madam, at that point.
From whom it is recovered, not specifically mentioned, madam.
Yes, what happened? Otherwise, he is in custody for 53 days.
53 days, madam.
This case 47, 48 notice served, my lord. Grounds of arrest is also there, my lord.
Yes, madam.
Considering
Sometimes one counsel just informed me that not only grounds of arrest, not only in English, but in Assamese also in vernacular also these grounds of arrest have been communicated. Huh?
It's not served.
Notice not, sir.
Not
Notice
served.
grounds are there only.
Only there.
seen all these places, but
Ground,
general
only a simple
notification
ground.
will be
The
recorded.
court red-handed. This is the ground.
In fact, those NDPS matters caught red-handed is sufficient. In fact, they know why they are not red-handed.
So be a ground of arrest, my lord, itself. In the otherwise, that ground is sufficient or not, that is, my lord, a different thing. But if on the ground of arrest, it is specifically mentioned that caught red-handed, my lord, that is sufficient, my lord.
As per that should be
And
followed,
whether
my
that
lord.
is a sufficient
Because with
ground
the
or
contraband, if one is caught, then
Yes.
he definitely why it has been.
yes.
53 days in custody, my lord. Only that.
That's
Yes,
what I'm just talking with
Yes.
Watagur also,
Yeah.
that 53 they may be considered. That
Yes.
FSL report is there otherwise.
Not yet.
Heard Mr. T. Hussain, Dilane, counsel for the petitioner, and also heard Mr. P. Watagur, Dilane, the additional PP, appearing on behalf of state respondent. This is an application for section so and so in connection with so and so. CD received, where is the same? It is submitted by Mr. Hussain, the learned counsel for the petitioner, that he was arrested in connection with this case on 01/03/2025 until and already 53 days in custody. Mr. Hussain accordingly submitted that they considering his length of detention, the prayer of the petitioner may be considered and further custodial interrogation may not be required for the interest of the investigation. However, the petitioner is ready and willing to cooperate the IO in further investigation of this case. Next paragraph, Mr. Watagur, the learned additional PP submitted in this regard that there are sufficient incriminating materials against the present petitioner and the contraband was alleged to have been recovered from the possession of the present petitioner along with the others. Mr. Watagur submitted that the case is still under investigation and however, he submitted that FSL is yet to be collected by the IO. Next paragraph, considering the submission made by learned counsel for both sides without going into detail of the merit of the case and considering the length of detention, I find that further custodial interrogation may not be required as the IO got sufficient opportunity to interrogate the present petition in custody. For whose satisfaction it has to be?
Special just come up metro, my lord.
This is just come up. Special just come up. Okay.
Deep.
42. We asked for no.
Yes. My lords, on the last occasion, the LCR was called for, however, it has perhaps not yet been received. Nevertheless, my lord, I have annexed the certified copy. My main ground is that I was not served with the grounds of arrest, as can be perused from the arrest memo at page number 38 and the section 50 notice on the next page. So that is the main ground, my lord, that I am praying to be enlarged. And otherwise, my period of detention is 325 days as on today. And the charge sheet has been filed and the learned court is taking cognizance of the matter. However, the main accused has been absconding. And therefore, also, there is no likelihood that the trial would start or culminate any sooner. That is another ground, my lord, on which I press. My lord is aware about the Gurbakh Singh CBI landmark judgment, where it has been said that an accused who is out on bail is in a better position to defend himself. Notice for Nasrada, page number 38. Yes, page 38 is the arrest memo, and the next page is the inspection memo. And page number 41 is the section 50 notice, my lord, where the grounds of arrest were not furnished to me.
It's otherwise a case of commercial.
It's a commercial.
801 point.
Yes. My lord, but from the Caesar list, my lord, where is the Caesar list? It was seized from a shop.
1.1 kg.
It was seized from a shop which belonged to the absconder. And it is clearly stated in the FIR that the shop was under lock and key, and the key was with the absconding accused. And I was simply arrested from another shop across the road based on some sources which were never disclosed.
Did the LCR come, my lord?
My lord, already, my lord, without going into the merits of the case, I have annexed the certified copies from the arrest memo, and the section 50 notice is clear that the grounds of arrest have not been furnished. So that alone is the ground for granting me bail, my lord, as per the landmark judgments. My lord is aware. And also considering the period of detention, my lord, kindly consider my case.
Whatever. Yes, already furnished the certified copies, in fact.
Yes, ma'am.
Of those notice as well as the arrest memo and inspection.
Yes.
And undoubtedly, admittedly, sorry, it's a ground of arrest only not been mentioned. That is one of. Otherwise, as you have submitted, definitely it's a huge quantity of the contraband was recovered. It's a commercial quantity also. And on the other hand, if one co-accused is suppose absconding, then the completion of trial or initiation of trial will take some time, I think.
Also, my lord, one of the core cases already been enlarged in bail by my lords. The bail order is at page number 77. He was also released on this ground of non-furnishing of grounds.
$77.
Yes, madam. My lord's order.
Oh, let's take it abroad. Days of arrest to 325 days. And one co-accused is still absconding. And nothing has been seized from the conscious portion of the submission. That is this submission. And Mr. Bortaku's submission is there. A huge quantity of contraband was recovered from the possession of the accused person. And it's a commercial quantity, but may not be a case for bail. Okay, whatever, otherwise we have already in other matters also we have reflected from your side that the commercial quantity and these are things are there.
Yes.
But the co-accused has already been granted, so parity has to be there. So that is due back.
Otherwise, my lord, what happened in all trial courts order, my lord, whenever someone accused person is produced, my lord, we have seen in all those orders that DK's versus guidelines were followed. And thereafter, on the basis of those following, after following those guidelines, my lord, trial court has passed order granting remand or police custody. Police custody as well. And thereafter, my lord, those matters also come before this honorable court also. And my lord, this practice is continuously going on regarding the providing written communication earlier, my lord, only after.
No, it's not there,
this
not
was
there,
not
no.
there, my lord. So, my lord,
Now, the 2-3 judgment of the Honorable Supreme Court had laid the so now onwards to all most of the things NDPS matters and some of the other criminals are also entered. And the probability of getting them or for procuring attendance will be very problematic for the learned trial court dealers. It will not be probable. Its probability is very less. Once they gone, it's gone forever. That's what is happening in fact.
What we can do.
So that's now 2-3 orders have already been sent to the Home Department also, as I have already submitted. To do the needful and be strict in that sense regarding the cost of arrest. And in some judgment, it is also said that verbal communication may be there, but written has to be there because otherwise we cannot be at this stage to say that whether any verbal communication was there or not. That is the issue only. That's what we are also facing some problem, but no way out. Anyway, I have already 77 of us appears to sign up. Okay. Then.
We should just remove. I'm so obliged, madam.
Pocket silo, no? These are the ground kita mon likhi disu na already. Eta kori.
It is on record, my lord. My lord.
So we have taken those grounds only.
Those grounds, my lord, and co-accused, my lord, page 38. On the same footing, co-accused have been granted bail by your lordship.
यार नोटिस का मैसेज अंदर स्टार्ट है नोटिस का मैसेज नहीं केस की मगर he has not annexed the notice copy of the notice.
I have annexed, my lord. This is page. Kindly see, my lord, the page. Page 46, 47, 48, and this second page. I have annexed, my lord. Original copies. Lord.
Your petitioner's name is?
Name is Deepak Malakar.
50 is there, arrest memo is there.
Yes, ma'am.
Inspection memo.
Yes.
Certificate copy, all three are there.
Yes.
Have you received this one? What happened? 3 they have annexed only, arrest memo, notice and the inspection memo. Probably co-accused was also granted bail, na?
Yes, madam. Page 38, madam. Footing was also arrested.
So your petitioner is behind the bar since when? Now?
15/7/2023. It is same, madam. Arrested together. One year, 9 months, 7 days.
This water or anything?
Yes, no, very well.
So otherwise your petitioner is also in the same footing.
Same footing, madam. Arrested, 4 persons arrested in same footing. Deepak Malakar, Sagar Malakar, and some other 2 Malakars. In fact, my lord, I visited the Sagar Malakar's house. The possession was made from Sagar Malakar's. I am not engaged, madam. This is a part of merit, madam. However, my lord, on arrest procedure ground and also on merit, madam. If we go to the merits, madam, the possession is not from me. And Sagar Malakar is my lord police constable, and I am in home guard. Very poor person. I am not a government employee.
Otherwise, my lord, matter is pending since 23. So now only, my lord, they have raised this ground. Till now, at any point of time, my lord, those grounds were raised very petition.
This is the first application.
Page 39 on the order, same order will be there. खाली ये तो लिखो. So nothing has been seized from your position, your
Not my
house.
position, yes.
Allocated recovery was not from his position, conscious. Not from his conscious position, it went and ho, otherwise innocent, everything will be same. Date of arrest is also same, 15/7/2023. And 1 year in present case, Agor case to Tasle, 1 year, 8 months, 19 days. Now in his case, 1 year, 9 months, 7 days. Thanks. Otherwise, rest will be same. And Mr. Bothakur's submission is more or less the same. Okay, this is also case from Sri Bhumi. Sri. Okay.
Obliged. In this case, my lord, my name was not in the FIR. And no allegation made against me in the FIR, my lord. I was subsequently, my lord, my name was
Yes, you are not in the FIR named accused.
not FIR named. And no allegation against me in the FIR. Subsequently, my lord, in charge sheet, I was shown as an absconder. And thereafter, my lord, NBWA was issued against me. And in execution of NBWA, I was arrested. Page 28, kindly see. Page 28. Produced before arrest, Patagandhi PS on the strength of NBWA issued from his campus. So, my humble submission, my lord, that
So you were shown as an absconder and the basis of the NBW, we got arrested.
arrested, man. Arrested on 12/12/2023. Today is 1 year, 5 months, 10 days.
Yes.
My implication, my lord, in the charge sheet, kindly see page 26. Only this is the implication.
Please.
Page 26. May I read the last paragraph? During investigation, sufficient evidence under section 21C 2529 NDPS Act is found well established against the arrested accused person Saifuddin, so and second Tajuddin. These are the FIR name, my lord. Thereafter, my lord, it is also here to be noted that during course of investigation, several house searches were made, but found the co-accused person, namely Fazlumia, so second Sulaimanuddin, and Abdul Manor and Sajeduddin, absconding from their respective residence to evade police arrest. So, my lord, during investigation, the house searches were made on suspicion, my lord, and I was not found at home. So my name was entered in the charge sheet. Since in charge sheet my name is there, so my lord, NBWA is issued. So I am relying on, my lord, these 3 judgments, my lord, here. Tufan Singh, Polula with Ahmed Aramutta, and my lord, Dhirendra Kumar Chaudhary. Merely on suspicion, my lord, 1 year, 5 months time. In Tufan Singh, my lord, it is no case against me. If I go to the Tufan Singh, my lord, I cannot be detained.
So during investigation, you have to cooperate in lordship, because during his search, he has not ever, he has shown as a, later on, he has shown as absconder in the search sheet lordship. After NBW is issued, he appeared and arrested lordship. So let me face the client lordship.
Otherwise, what is the stage of the case at present?
Evidence stage, my
Evidence.
evidence stage.
Is there any evidence recorded already?
Yes, my lord. One, this is PW, one PW examined, my lord. I have annexed, my lord.
But I have got the record lordship, the charges framed against two accused, Saizuddin and Tajuddin lordship. Against this petitioner, such charges framed or not?
Charge not framed, my lord. I have also not found against, even the accused Salan is not there, my lord, against in the record. my lord. In fact, I was just picked up.
Only charge framed on against the arrested accused Tajuddin and from Saizuddin.
Saifuddin and Tajuddin, they are the main
They are-
accused person. Their FIR named also.
Against this person charge were framed or not is because he was arrested after charge was framed. Charge was framed on earlier dated 28/9/22. And he was
28/9/22.
22. And he was arrested on 12/12/23.
23. So without splitting up, my lord, the present is.
That order is not,
petitioner.
I have also said, that order is not reflected in the.
Yes, my lord. So how can the charge can also frame, my lord, without splitting up me?
Also, let the up to date.
The record is there, but up to date record is also there. Up to date record is there. This is just receipt. Trial is done is very haphazard.
One PW to examine.
So otherwise, you got arrested on when? 1,
12/12/22.
12, 10.
12/12/2023.
And charge frame against those accused lordship 28/9/22. And charge sheet was laid on 31/7/22.
Nothing against me, my lord. Police did not take any evidence against me.
Your petitioner's name is Saizuddin, no?
No, Suleiman Uddin.
Suleiman Uddin.
Not in the FIR.
And 1 PW was examined when? It was examined
It was a long
11/7.
11/7/20.
The split up order is there, I think. 11/7/2023. No, one order is there. 25/7/2023, one order was passed, wherein the next the session judge who took the charge, earlier session judge, he did not take any steps. But subsequently, order was passed that on the perusal of the case record, it shows that the charge is yet to be framed against the absconding accused person. So it was an order. So thereafter NBW was issued.
Okay.
So that was the PW was examined prior to their arrest, and that is the whether there was any split up order or whatever. It's a irregular order, obviously, but it's not there. But only against 2 accused persons the charges were also framed, and 1 PW was also examined. Subsequently, it has come to the knowledge of the court that the charges against the absconding accused persons are yet to be framed. So that thereafter NBW was regularly issued.
Yeah, they
And he kept arrested. So that is the present position of the case. So it's not the case that without framing issues, PW was examined. It's not that. PW was examined earlier to that. Anyways, any other submission, Mr. Goswami?
No.
It's Chaudhary, I'll pass you out.
Nice.
Out of the past video.
Good night.
Good night.
Topic not yet filed.
Not yet filed. Then let it be 89 days only what to do without we going by the merit. Otherwise, I have seen the case is not, even if suppose penetrative sexual assault is there or not, it otherwise, but it's a very stress case. 39. Heard Mr. Bormon, no? Your name is? Huh? Bormon is Arpon. Oh, acha. We are on 39. No?
39.
So, heard Mr. Arpon, the learned counsel for the petitioner, and also heard Mr. P. Waterco, the learned additional PP, appearing on behalf of state respondent, and Ms. M.K. Brown for the appearing, the learned amicus curiae, appearing for the respondent number 2 of the informant. It is submitted by Mr. Kaur. You have received the CD also, no?
Yes.
This is an application under section so and so in connection with so and so. CD received, where is the same? It is submitted by Mr. Kaur that the present accused petitioner is innocent and he is no way connected in the alleged offense. However, he is in custody since last 89 days and hence, considering his period of detention, he may be allowed to go on bail. Mr. Kaur further submitted that from the plain reading of the FIR itself, it is seen that case is not, there is no ingredients to attract section 4 of the POCSO Act, though it has been registered under the said section of law. So, however, the petitioner is ready and willing to cooperate the IO in further investigation of this case if he is allowed to go on bail. Next paragraph, Mr. Portaco, the learned additional PP submitted in this regard that there are sufficient incriminating materials in the CD, especially in the statement made by the victim. 164, victim under section 163 is now it is 183.
Yes, 183.
183 BNSS and hence he raised objection and submitted that it is not a case for it's not a fit case to allow the accused petitioner to go on bail. However, he submitted that on inquiry made by him, it is submitted by the IO that the Case is yet to be charge sheeted. And case is still pending for investigation.
FSL report not yet.
As the FSL report is not yet collected by the IO. As MS MK Brown, the learned amicus curiae for the respondent number 2 also raised objection and submitted that in considering the age gap between the victim and the accused petitioner, and also considering the materials the statement made in the FIR, as well as the statement made by the victim, it is not a case to allow the accused petitioner to go on bail. Next paragraph. Considering the submission made by learned counsel for both sides, I have also perused the case diary, and it is an admitted fact that there are sufficient materials collected by the IO, but it also cannot be denied that the accused petitioner is behind the bar since last 89 days. And the IO is not in a position to file the charge sheet within 1 or 2 days or within the statutory period. So considering without going into the merit of the case, detail of the merit of the case, only considering the length of detention already undergone by the accused petitioner, and it a fit case to allow the accused petitioner to go on bail for this where it is pending.
This is your special, this is a Harvey case, special that's POXO Kamrup at Aminga.
Special just POXO Kamrup bracket or Aminga. Subscription. Okay.
Okay.
May please your lordship, please. So in between, my lord, 20 grams of heroin, my lord, 46 days, my lord.
Is what happened?
19 gram of heroin from the possession from the house of the present petitioner. FSL report not yet received. Otherwise, 47 all are grounds for arrest.
Mr. Doctor is not taking that ground out today. Only 46 days he is taking.
Yes.
Anyway, 46 days is a sufficient days, I think. Then if the FSL is not yet collected, then
Yes.
it may take some more time to collect.
Ground of entrance.
Heard Mr. NJ Doctor, the learned counsel for the petition, and also heard Mr. P. Botaku, the learned additional PP, appearing on behalf of state respondent. This is an application under section so and so in connection with so and so. CD received, where is the same? It is submitted by Mr. Doctor that the case is of intermediate quantity and the LS recovery is how many grams?
19 grams.
19 grams.
19 grams. LS recovery of the contraband is only 19 grams, which falls within the intermediate quantity. Full stop. Further, is submitted that is accused petitioner is behind the bar since last 46 days, and considering his length of detention, he may be released on bail. Full stop. However, the accused petitioner is ready and willing to extend his cooperation in the further investigation of this case if he is allowed to go on bail. Next para, Mr. Botaku, the learned additional PP submitted that there are sufficient materials against the present accused petitioner. However, the IO could not collect the FSL report till date. Mr. Botaku, however, Mr. Botaku accordingly raised objection and submitted that considering the materials available in the case diary, it is not a case. The prayer for bail may not be considered. Next part. Considering this submission made by learned counsel for both sides, without going into detail of the merit of the case, only considering the length of detention already undergone by the accused petitioner, it is found that sufficient. The IO got considerable period for his custodial interrogation, and accordingly, further custodial interrogation may not be necessary for the interest of the investigation. To whose satisfaction this one?
Special Judge NDPS Borbetta.
Special Judge NDPS Borbetta. Special Judge bracket of the NDPS Borbetta. Okay. These are the hearing are finished. Positive protocol context.
Upgraded item 43 and 44.
Mr. Chaudhary. Yes. I think you are at the other side. Where is the other side?
This matter I'm being led by Mr. Ken Chaudhary. He's on legs, my lord. And he has arrived only yesterday night from Arunachal. I could not brief him on this matter. He has requested me to ask your lordship if
So,
this.
but on the last occasion also, Mr.
Yes,
Chaudhary,
yes.
there was a report that no further adjournment will be given.
Yes,
in fact.
my lord, but he, unfortunately, we could not even get to meet him. He came last night late when I was unable to prepare the case. That he has instructed me to inform your lordship. He has asked for a short date next week.
Then you could have made such prayer in the morning hours. It's Mr. Chaudhary was there. I have seen. That's why I just called because I have gone through the case record yesterday night and then saw that these matters are there. So
Lordship,
next Tuesday.
let it be day after tomorrow, Lordship. Because in any case, Lordship, the relief that they are now enjoying is based on a CBI case which was stayed by this honorable court. So the proceedings under the PMLA was stayed. Now, the stay order in the CBI case is no longer there because they have withdrawn that case. My friend has withdrawn that case. And for the stay order granted in these cases, now we are not able to proceed. The stay in the CBI cases has been vacated long back. It's more than 2 years now. So for last 2 years.
So now the cases are in the PMLA.
Yes, it's a PMLA case. Case is very simple. We have issued them summons. Now their ground was, since the CBI case, that is the predicate offense, that has been stayed by the honorable court. So the PMLA case may not proceed. Court granted them a stay. Now they have withdrawn that case against the CBI. So nothing remains. We can proceed. But there being a stay in these cases, we are handicapped. So lordship, maybe day after tomorrow. It's
If just a second, if day after tomorrow, 25 or both are selling this. Which day more than maximum 24th basis 25th. This same. Many matters.
lordship, the earliest.
24.
The,
Many matters. And then we can do one thing, it will be fixed at 2.
lordship, that's fine.
If it is, isn't it? Please inform Mr. Chaudhary also that it will be fixed at 2. If any other matters are there, so it may be adjourned and at 2 will take up the matters.
Yes.
Because is that 4 or 5 matters, 3 or 4 matters they all are connected, I think.
Yes.
Petitioners are different or what?
Different. In fact, it's the same issue.
Same issue.
Same issue. And the same impugn orders.
All are doctors, I think, na?
2 are doctors.
2 are doctors. 24th of November, 24th and 25th lots of matters are there, na? Already. So maybe on 28, 29 ki baat aali not. 29, can it be 29?
Madam, may fix it on 6th at 2. 6th of May at 2.
That is asking for too much.
At 2, and that is why I'm saying at 2, because in any case it will be taken up on 6, because I believe there is some other scheduling conflict as well. I was asked to request 25th, 24th would have been fine, but my lord, it will be difficult. So at 2, I'm agreeable to that. There is no need for mentioning it. At 2, it can be fixed on 6th of May. It is a Tuesday, hearing day as well.
Thursday. It is Tuesday.
Tuesday.
30, 31, 32, and 33. No, 33 is different, no?
3 cases lost.
30, 31.
31 and 32.
32. You are Mr.
N. Borwa.
N. Borwa. At the request made by N. Borwa, Mr. N. Borwa appearing on behalf of Mr. K. N. Chaudhary. For the petitioner. The matter has been adjourned. Also hard query, Mr. R.K.D. Chaudhary is also there. He was a Can proceed, Mr. S.K. Medi, Enforcement Department. Mr.
Lordship, previously Mr. Mehdi was there. Thereafter, Lordship, they requested me to appear.
So now you are dealing with the cases. So you are also, we were designated as a standing counsel. DSGI, yes. So you're looking after this things now. DSGI ko diba? Mr. R.P. Richoder. Hard ko diba? If I so and so appearing on behalf of Mr. P.N. Chaudhary at the request made by the 6th of May ko diba at 2 p.m. So we are listing out these 3 matters at 2 p.m. on 6th of May. But see, these are the matters of 2019, I think. So further adjournment should not be there.
I will
The
not take
request
up
made
here.
by you only I have given. Otherwise, if we go by the earlier order, it is as a no further adjournment will be given, in fact.
I'm
Was
not
there.
making any further.
So as 6th of May at 2 p.m. We are fixing it on 2 p.m. Okay.
I'm okay.
But Chaudhary was waiting for, I have seen you in the first hours also, first half also.
No,
So
actually,
information, huh?
I was not in contact with my senior as well because he was shuttling between courts and even I could not meet him yesterday as well. In fact, I believe he was in Arunachal Pradesh. He arrived late. So I could not even meet him.
Mr. Chaudhary, okay then.
I apologize, ma'am.
43 and 44.
This one I is there, na?
Yes, my lord.
Yes, I is for, yes.
My lord, petitioner number 1, his name has been wrongly mentioned in the cause list of the bail application, my lord. It should be Inamul Haq. We have written it Imanul. So for that, we have filed. It may be raised as,
Petitioner number 1.
yes, my lord, only petitioner number 1. It should be INAMUL. We have written IMANUL.
Actually, Inamul.
Inamul, as per the forwarding report and also other report.
Okay, Mr. Pothapur. Yes, any other submission from you? It's okay. Now bail is for?
Bail is, this petition is under 483. Well, they are behind the bar since last 57 days. Well, lordship will,
Then we, what to do? Hearing both the items, I will be allowed, it's okay. But correction has to be there, otherwise if your petition will be, most probably cause title has to be, there should be a correction. Or no, can be.
well, Lord, if lordship gives an order in that, saying that petitioner number 1 may also be read as this, alias, then that will also
do.
That will
Okay,
also do,
okay.
my lord. Lord, may I go ahead with the bail application, my lord. Lordship will find the FIR at page 8. Relevant portion will be at page 12, that is the translation person. My lord, 4 petitioners herein and the victim boy, they were the patient in a rehab center. There were some altercation. Well, though, my lord, in the FIR, it is stated the staff. Actually, we the petitioners are also patient in the rehab center. We are also there. Whatever, my lord, there was some scuffle, my lord, and it was alleged that we have hit him with a stick, iron stick, my lord. And on that allegation, we were arrested on 26th of February. And since then, we are behind the bar. Lordship, may kindly see the forwarding report. I'll just come to the forwarding report, my lord. It will be at page 14, 15 it starts. Lordship, both the FIR and the forwarding report that just speaks about what the injury they have received by virtue of that assault as alleged we have made, my lord. And Lordship, what I want to point out, my lord, that is the Caesar list. That is the Caesar list, my lord, at page 21. Has your lordship got it? Page 21. Well, only one piece of plastic pipe length 2 feet. Description of the seized article. There is another one Caesar list at page 23. One mobile handset. So, my lord, the allegation is there. We have assaulted the victim boy, who is stated to be a minor, with a sharp steel rod, but nothing has been seized by investigating police. And also the FIR and forwarding report does not speak about what is the injury they have received. Well, in the scuffle, the cloth, that is a gamusa, my lord, that got removed somehow. And because of that, my lord, section 12 has been of POCSO has been imposed. Section 12 of the POCSO, my lord, it is 3 years imprisonment. My lord, it says, my lord, sexual harassment that has been described in section 11 of the Act. My lord, the ingredients required under section 11, my lord, are not applicable in this case at all, my lord. No, it is in the scuffle, something has happened. There was no intention. Section 11 basically says we can intend if we do something. There is nothing as such. All these boys are of 20 ages, are very small, young boys, my lord, 23 years, 25 years, 24 and 26 years they are. They are also patient. Even the victim itself is a patient in the rehab center. Something has happened, my lord, and it was captured in videography. Maybe it was under CC camera or something else, my lord. They say it was videographed, but no allegation that it was circulated or something like that. So, my lord, 57 days behind bar, my lord.
How many days?
57 days today. Arrested on all the sections are, my lord, 60 days offense, except 118, because it says grievous injury using deadly weapon. My lord, nothing has been recovered. Only one pipe, my lord. So I humbly say, my lord, this section is also not attracted. They may be enlarged on bail, my lord. And there was another accused, the owner of the rehab center. He has already been released by the learned additional district judge Dorong.
After circulation of that video footage in social media, this FIR has been lodged by the mother of the victim. Initially, that incident occurred on 17 to 25, and thereafter on 25 to 25, this FIR has been lodged by the mother of the victim after circulation of the regarding that physical abuse of her son, in the social media. And now, police has also collected that video footage and also burn it in the form of CD. And in that regard, that CD was also now seized by the police. And regarding that injury report, injury report on the because incident occurred on 17 to 25, injury report is on of 25 to 25, as per the injury report, no external injury seen. That is, after 6 days of the incident, this injury report is prepared by the doctor.
But what I want to say, suppose cases also registered under 1182.
Yes, yes.
So as we said that
Yes,
it's a
yes.
case of suppose grievous hurt.
Yes.
So after 6 days, if his grievous hurt was there, or otherwise also if grievous hurt was there, the boy definitely he should be admitted in hospital immediately
Yes.
after the incident.
Previous hurt,
That is not
that
there. I
ingredients
think.
is not
The
there.
ingredients is not there. But otherwise, yes.
Otherwise,
Section 12, 21, there may be some incident, maybe, I don't know, it's not clear in the FIR also, what kind of things.
Rehab center, this type of
Things are going
incident
on.
continuously going on. It cannot be said that there was no physical abuse.
No,
But
you cannot
regarding
say.
that
We
injury,
are
report,
hearing, yes.
Concerning-
Yes, Ms. Pooja.
My submission is in a rehab center. First thing, my learned senior has just mentioned that these petitioners are also patients in the rehab center. This is not a plea anywhere in the petition. In the FIR, it has been stated that they are the staff of the rehab center. So far as staff are concerned, they have a liability towards the patient. There is a trust. On the basis of trust, they are admitted in the rehab center. If these things keep on going on in rehab centers and the court allows the bail, then there are chances that the incidents will increase day by day. And so far as grant of bail to one of the co-accused is concerned, he was the owner. The direct allegation was not there against him as regards commission of the offense. It was only that he did not inform the family of the victim. In my humble submission, the bail should not be granted at this stage.
Just to counter, whatever. In the statement that we are patient, is there, paragraph 4 of my petition, I have stated it. Only just to point out, my lord, it is a statement on affidavit, my lord. In para 4, my lord, may I read it, my lord? That is, it has been alleged that in the FIR that the son of the informant was beaten up with steel sticks by the staff of the rehab center. Police arrested the accused person on mere suspicion, as the accused persons are themselves patient in the said rehab center. This statement is there, my lord. Yes, my lord, length of detention and also there is no injury, my lord. Nothing has been recovered also, no deadly weapon recovered, my lord. My humble prayer, my lord, investigation must have completed, my lord. We may be allowed to go on bail. And also, my lord, this miscase, my lord, petitioner number 1 may also be read as, my lord, that corrected name. It should be, my lord, Inamul Haq, INAMUL, my lord. Not will can be allowed.
But order to be লিখিব sir Inamul, not Imanul, Inamul.
Otherwise, my lord, there's a submission of my friend, my lord. But that they are also the patient. Regarding that, my lord, statement of the victim is also there. But from CB also, nowhere it is reflected that, my lord, they are the patient.
They are the patient. They are the stated to be they are the staff.
Yes, my lord.
43 যেটো আই আছে এটো এটা জাস্ট এলাও করা অর্ডার করে দিব এলাও করা অর্ডার করে রিপ্লাই দিব যে petitioner number 1 may be read as Inamul Haq instead of Imanul Haq in this in Inamul Haq এখানে দিলে হবে বাকিখিনি এলাও করে দিলে petition কোন ডিসপোজ করে দিব পাইবা না মিস্টার টিআর শর্মা আর বাকি মিস্টার ই বটাকো এন্ড ডক্টর পূজা আগরওয়াল amicus I to dispose করে দিব this is next to 44 টা হোক heard Mr. T.R. Sharma, the learned counsel for the petition, and also heard Mr. P. Botaku, the learned additional PP, appearing on behalf of state respondent, and MS and Dr. P. Agarwal, the learned amicus for the respondent number 2. This is an application under section so and so, connection with so and so. CD received, where is the same. Next paragraph, it is submitted by Mr. Sharma, the learned counsel for the petitioner, that all the petitioners are the young boy of, is it about 22, 20, how many years they are? 22?
They are within the range of 22 to 26 years.
22 to 26 of years, 26 years of years.
23 to 26, my lord, I'm sorry.
23 to 26 age group of 23 to 26 years of age, and they were also admitted in the said rehab center as a patient. Poster. There was an altercation and scuffle took place between the patients, and in that scuffle, the victim. You're not saying sustain any injury. Regarding the injury part, you're not saying anything. The scuffle, only scuffle took place, but no such incident had taken place as alleged in the FIR. More so, from the CSLS, it is seen that only one plastic pipe was recovered, and except that no other weapons or materials were seized by police during investigation. Mr. Sharma further submitted that in the forwarding report also there is no mention about any injury, any specific injury sustained by the victim of the present case. Poster. All the accused petitioners are behind the bars since class 26 to 2025, and hence, considering their length of detention also, they may be released on bail. However, they will extend their cooperation in the further investigation of this case. Next paragraph, Mr. Botaku, the learned additional PP, submitted in this regard that the alleged incident had taken place on 17/2/2025, and the FIR was lodged only after circulation of the video on 25/2/2025.
By the mother of the victim.
25
Yes, from 25 to 20.
Or even 25 to 2025. Listen, 25, 25. And as the victim was examined after 6-7 days of the occurrence, there was no injury, external injury was found at the time of his examination. Further, he submitted that in the case diary, there is no mention that these petitioners were also admitted in the state rehab center as a patient.
As per the witnesses, they are the employee of that rehab center.
And as per the witnesses, they are the employee of the rehab center and not the patients. Mr. Bottom accordingly raised objection and submitted that the petitioners bail may not be considered at this stage. Out of his Sharma submission, out of submission, Mr. Sharma further submitted that there's no ingredients to attract the section 118 subsection 2 of BNSS as well as against the FIR, as well as in the FIR. Next paragraph. MS Dr. Agarwal, the learned amicus, submitted in this regard that this kind of activities are going on most of the rehab center, and the accused persons who were stated to be the staff of the said rehab center. The rehab center were trusted by the patients of the victim and victim, but in the name of the treatment, the staff of the said rehab center were doing such things or such things along with the patients. She further submitted that one of the co-accused who was released on bail was the owner of the rehab center, and he was not present at the relevant time of incident. Ms. Agarwal accordingly submitted that Dr. Agarwal accordingly submitted that this is if the present accused petitioners were released on bail, they may get encouragement and to do further this kind of crime further. Next para, considering the interest submission made by Lamin Council for both sides, I have also produced the case diary. It is seen that it was alleged that the victim sustained grievous hurt at during the incident, but there is no medical report to that effect. Rather, it says that there was no external injury detected at the time of his examination. Further, it is seen that all the accused petitioners are behind the bar since last 57 days, and hence, considering the length of detention already undergone by the accused petitioners, I find that the IO got sufficient opportunity to interrogate the present accused petitioners, keeping behind the bar since behind the sufficient keeping them in the custody. I find that further custodial interrogation may not be required for the interest of the investigation, and accordingly, and hence I find it a fit case to extend the privilege of bail to the present accused petitioners. Where it is pending?
Well, the special judge Dorong.
Special judge Dorong, to the satisfaction of special judge Dorong Mangolde.
Obliged, madam. I'm deeply obliged.
Yes, they are. Entry for
Item 22.
Yes, item 222 we have received.
The wildlife, specialty the wildlife.
Oh, acha, acha.
Here, then. Otherwise, we have appeared, my lord, before the IO. The maximum punishment is 3 years.
You have already appeared also.
Lordship.
You were on interim earlier.
Yes.
আচ্ছা। SLPP, what is it then? So, I ঠাকুর is also dealing with it.
Yes, he was here.
He was here only. Just for time being only.
Yes, yes.
For time being, I'm keeping.
Oh, my lord, or day after tomorrow.
No, he was here only, Mr. Bhattakur.
Yes, he has the case diary.
No, case diary is okay, but he was personally, he was present, in fact. I have seen, huh? For the time being, say for 5-10 minutes.
Lordship. Much obliged.
24.
Lordship 24, Mr. Anjanotto will appear, Lordship, after sentence, Lordship.
I don't know. Am I?
Minutes, Lordship.
No, I don't know. If I, till my rising, if it appears, then it's okay. Otherwise, it will be over.
26.
Yeah, please, my lord.
Yes.
The fear for period is bail, my lord.
Notice was not issued.
As per my lord, office note dated 23/2025, my lord. The respondent number 2 not been received, I think.
Notice received.
Not received. Not received. 23/25, my lord. That's what. Office note.
No, one office notice of 4/4/25. Your office has already received the notice, I think.
But it is served or not, that wait for instruction, Lordship.
Waiting for the instruction. Then you take instruction when it can be fixed.
But my lord, there's no interim, my lord. Kindly see the page 11, my lord, the vernacular affair, my lord. May I read, my lord?
No, POXO, we generally cannot give interim. We are not anyway. So it is a case of that allegation of rape is also there.
As per mention, my lord, this affair, but my lord, this allegation is after married, my lord, this vernacular affair, my lord. সন্মানপূৰ্বক বিনীত নিবেদন এই যে উপৰোক্ত পদকীয়াজনে মোৰ ছোৱালী so age about 14 years ভাল পোৱা প্ৰলোভন তোক নাপালে মই বলিয়া হৈ যাম বুলি মিঠা কথাৰে ফুচুলাই লৈ 22/1/25 আৰু 28/25 তাৰিখে ৰাতি প্ৰায় 20 মান বজাত একে গাঁৱৰ ৰাজা পেগুৰ মানুহ ঘৰত ৰাতি ঘৰত নথকা ঘৰত ৰাতি ধৰ্ষণ কৰে this allegation এই কথা কবলৈ মানা কৰা যদিও ছোৱালীজনীয়ে বৌশ্ৰী মনালিসা দলে অৱগত কৰাত আমি ঘটনাটো যোৱা ইংৰাজী 7/2/2025 তাৰিখে গম পাওঁ this incident happened, my lord, 22/1/2025 as per FIR, my lord. And now, my lord, after information of the father, my lord, 7/2/25, my lord, these victim girls who lost the FIR, my lord, name, my lord, Gagan Dale, but FIR lost, my lord, on 14
No, sir, but it is a
2025.
POXO. We cannot
Delay
pass
lodging.
any
That's
order
7
without
days
hearing the
delay
other
lodging
side.
FIR, my lord.
Pardon?
After 7 days delay lodging, my
Yes, yes,
lord.
but notice has to go and notice has to be there. We have take instructions, Mr. Kusami. 28. Okay, I heard Mr. A. Doctor, the learned counsel for the petition. Also heard Mr. D.P. Kusami, the learned additional PP appearing on behalf of state respondent. This is an application. No, sorry. So you like from it is submitted by Mr. Kusami that till date he has not any instructions regarding the service of notice on the respondent number 2.
My lord, date maybe can it be? My
CD,
lord?
yeah, otherwise we have also CD received. CD already received. Retain the CD till next date of listing. Yes.
1st May, my lord.
1st of May.
1st of May.
1st of May. You take instruction within that period. And 1st of May so and the learned additional PP is hereby asked to take instructions regarding the service of notice. Okay.
For orders, item 33.
8 to 26. 26. This is? I think 33. No, it মাটি দিয়ক নহ'লে এই যে টাইমিং বঠা পৰা আহি পাইছে 33 আপনি yours আহে 33 and normally it will appear কৰা নাই none appears on call for the petitioner side this after 2 weeks this 1 week or 2 weeks 2 weeks 33 you're saying that this one. Whatever I say, to go to
22.
His statement has been recorded and he has not confessed to anything so far, my lord. So, my lord, let him cooperate whenever required. And if he misses a date, my lord, then it can be cancelled, my lord. That observation may be given, my lord.
This is a date in a sense, definitely there will be an order for his cooperation will be there will be. But suppose if there is any, if he misused that property liberty or that whatever, then you can also very well approach before this court for a prayer for cancellation. Okay, otherwise there will be an order or there will be direction to them. Heard Mr. S.D., the learned counsel for the petitioner, and also heard Mr. I. Botapo, the learned special PP wildlife. This is an application, the section so and so, in connection with so and so, CD receipt, where is the same. It is submitted by Mr. Day that the accused petitioners have already appeared before the IO and here their statement are already recorded and they are cooperating in the investigation of this case. Mr. Day further submitted that they are also ready for further cooperation with the IO. Next paragraph, Mr. Botapo, the learned additional PP submitted, learned special PP wildlife submitted in this regard that the accused petitioners are already appeared before the IO and they are cooperating in the investigation of this case. However, their cooperation may be required in the further investigation of this case, and accordingly, he insisted to direct the petitioners for their cooperation. Next paragraph, hearing the submission corridible, extended cooperation corridible, and that order for interim bail was on 10/2/2025, which will be made absolute, with a direction to appear before the IO or investigating authority as and when your cooperation is needed.
Okay. Most obliged.
24.
Sorry, madam, I was not there. May it please, your lordship. My lord, it's a second bail, madam. Earlier it was rejected. Lordship may kindly come to page 21, lordship's order.
Yes.
Paragraph 4, madam. It is submitted by Mr. Chaudhary, learned senior counsel, that the present accused number 1, Raju Ali, had love affair with the victim, and as there was a dispute between both the family members, and she did not attain the age of majority. The family members of the accused number 1, that is the present petitioner, refused marrying minor girl. On the day of the incident, the father of the deceased called the accused number 1 in their own house, and he had assaulted by the father of the victim in presence of her. And when she came to rescue him, she was also assaulted by the informant, locked her in a room, and thereafter, out of fear and depression, she committed suicide. Well, this is a case of suicide, madam. Now, lordship will turn to next paragraph, paragraph 5, madam. Mr. Bora so-and-so, madam, from the materials available in the case diary, it is seen that the victim had love affair with the accused number 1, who is already arrested in connection with the said case. And so far, the materials that have been collected by the IO, it is seen that the accused number 1 is involved in the alleged offense. However, till date, postmortem report could not be collected as the report from the FSL is not yet collected by the IO. So at that point of time, my lord, the PM report was not available before this court, my lord. Now the PM
PM is FSL is waiting to, that's why the
cause of death is pending, Lordship.
PM report, my lord.
Still pending.
Still pending. PM report is pending because of the FSL report.
PM
FSL
report, I think.
PM report, I said.
Yes, PM report has.
What is there in the PM?
The opinion regarding cause of death is pending. And by
But
Lordship,
otherwise, what is the
otherwise-
injury and all?
injury no, not detected, and dark brown ligation mark non-continuous,
That's
completely present over neck. On dissection undertaking issues on Lordship, no injury over other parts, Lordship.
So what things are sent to the FSL for
Nothing is
viscera?
only thing is
Viscera has already sent, or what kind, what thing? But non-continuous ligature mark was there.
Yeah, Lordship. And earlier statement of the mother of the disease procedure is not here. Now it is here.
Your petitioner is, who is he?
I am one is the father, number one of that accused number one, and one is, petitioner number two is the neighbor, madam.
Who believes this?
My son had an affair, madam. That's true, madam.
The son has an affair with that disease procedure. He is the father of that main accused number one. Okay. And
Therefore, it's not a case of matter 302, madam.
the statement of the
It is
mother.
registered as 302. No, I think
1031, madam.
1021 is the,
BNS.
no, BNS, it is,
Yes.
it is murder.
Just.
PNS.
No, BNSS, no, BNS like that.
1031 is murder. They call imprisonment for life.
103, na?
103 within bracket one, murder.
The statement of the mother of the disease care was recorded, Lordship. He has her statement, Lordship. He's on suspicion, Raju was killed, her daughter, Lordship. FIR was made between the Raju and
Against these two petitioners, what is there?
nothing speaking against him. This petitioners. Only he saw that Raju had gone out from their house prior to incidents.
Gone out from their house.
As per their house statement, the mother of that is Lordship. And other witnesses heard about that, this petitioner was involved. Nothing but. Other than allegations are there, but her mother's statements against Raju, not against this petitioner.
Mr. Anjay Datta, the learned counsel for the petitioner, and also have Mr. D.P. Goswami, the learned additional PP, agreeing on behalf of state respondent. This is an application under section so and so in connection with so and so updated case report along with the postmortem report has been received. Where is the same? It is submitted by Mr. Dr. the learned counsel for the petitioner that these two petitioners are not at all involved in the alleged offense. However, it is a fact that the petitioner number one, who was the father of the prime accused, who had love affairs with the victim. But apart from that, he is no way connected in the alleged offense. Mr. Doctor further submitted that you have already collected the certified copy, na?
Yes, ma'am.
Postmortem report.
Yes, ma'am.
He has
That's all.
already collected the certified copy of the postmortem report, which also shows that there is no other injury except the ligature mark on the non-continuous ligature mark on the neck of the present petitioner, and which may be a case for suicide. But these two petitioners are no way involved in the alleged offense. He further submitted that from the ingredients of from the statement made in the FIR as well as from the postmortem report, a case also does not fall under section 103 oblique subsection 1 of the BNS as registered. However, these two petitioners are ready and willing to cooperate the IO in further investigation of this case. Mr. Dr. Fullstop. Mr. Doctor further submitted that their earlier bail application was rejected by this court only with the observation that there was that the postmortem report was not collected by the IO and was not collected by the IO. No, postmortem report was sorry. With the observation that the FSL was not collected by the IO, and hence the cause of death was not mentioned in the was still no. Observation that the postmortem report was cause of death could not be given in the postmortem report as the report from FSL was yet to be collected by the IO, and also considering the fact that the father of the victim implicated these two accused persons. Next matter, Mr. Goswami, the learned citizen PP, submitted in this regard that the FSL report is still awaited and hence the cause of death is yet to be determined by the doctor. However, he submitted that from the injury, from the description of the injury made in the postmortem report, it is seen that there was a non-continuous ligation mark on the neck of the victim and no other external injury was found on the body of the victim of the deceased. Mr. Goswami further submitted that except the informant, the other witnesses did not implicate the present accused petitioners in their other witnesses did not implicate these two petitioners. Further, he submitted from the statement of the mother of the victim, it is seen that she implicated the accused number 1 oblique the prime accused, who had love affairs with the victim. Expert, considering the entire submission made by learned counsel for both sides, matters so far collected by the IO vis-a-vis the injury as described in the postmortem report, I find that custodial interrogation of the present petitioners may not be required for the interest of the investigation. Accordingly, I find it a fit case to extend the privilege of pre-arrest bail, so and so, condition with the DDP. Okay, well granted.
I'm deeply obliged.
My lord, this application is made under section 483(3) of the BNSS, praying for cancellation of the bail.
Cancellation?
Yes, my lord, in this case, my lord, if you also see the order at page 10.
Page?
Yes, page number 10.
Page number 10.
The error occurred due to the misconception of the department. They registered the case initially in 20B. So in that context, there's no deficiency in order. It's correct. But when the FSL report came out, my lord, FSL report is page number 17, my lord.
17.
17. The main project, page number 18, my lord. Continue for 17, page number 18. The result of examination, my lord. In the second last paragraph, my lord. Result of examination, my lord. The exhibits were analyzed by chemical tests, thin layer TLC, gas chromatography and analysis. Chemical test and chromatography analysis gave positive test for cannabinoids including THC. Based on the above methods, results obtained are given below. Cannabinoids within bracket dronabinol, and dronabinol, my lord, is a drug whose commercial quantity comes to 50 grams, my lord. So the case will be now registered at 20C, my lord. So necessary application has been filed for correction for the learned session special judge. Therefore, my lord, since the matter has become now it's in the commercial quantity, so my lord,
We have already filed the application.
yeah, we have filed the application, then the order has been passed. We have not obtained the order.
You have appended the order also? No.
No, my lord. Why could not? Because it was filed just immediately before filing of this, a day before filing of this application.
That order should be here, in fact, because if it is your petition is supposed considered by the trial court below or the learned special judge, that will be your now your case may be registered under 20C.
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 At this
So
stage, let the notice go, my lord, because it
in
is
the
there.
meantime, you just
In the meantime,
submit through an additional affidavit
I will file
your order passed
My
by,
lord.
because that will be required, in fact,
my lord.
if it is that is the case. Otherwise, is the person is still any hope you have any, I mean, though he is in bail, suppose
My lord.
his cooperation, if needed, whether you have sent any notice or anything
My
to
lord, these people are from outside, my lord. Once they go, my lord, it's very difficult.
where
to bring
from
them.
there?
They are from Kerala.
They are from Kerala.
Kerala, my lord. And I don't know, my lord, whether they name whether they
Because
will
but the for the cancellation of bail,
yeah.
the notice has
But
to
that's-
be yes.
who will-
Otherwise, without hearing them, cancellation of bail is not proper also. It's not justified also.
We'll take the steps.
If it is the addresses are proper, then you take a steps, let
We
us
will
see.
take the steps, my
Yes,
lord,
yes.
and because this majority in the cases, the addresses are not fake, in fact, but they move from that place. I've seen in many cases they remove, they sell the property and move to other
Yes,
places.
yes. These
are
these
like
are yes. So basically now one address is there,
Address is
but
so we will
don't
send
know
notice.
whether he is there or not.
Yes. We'll take steps. In the meantime, I will file an affidavit.
Yes. Simple order, hard Mr. M. Kiboro. You are standing counsel,
Senior standing counsel DRM. my lord.
DRI, no?
DRI.
Senior standing counsel DRI. This is an application, interlocutory application filed for so and so corridor. Issue notice corridor. Issue notice to sue. In the meantime, you file your. So it will be listed after 3 weeks. We'll do,
My lord.
Mr. Pok. List after 3 weeks immediately. You take steps. Let us see. Let us hope for the best. If it is there, still there, then notice may serve also. So hope for the best. Otherwise, we also feel that if the person from the outside state, it's very difficult on our part to procure the attendance. It's a very true fact. Otherwise, also we are now dealing with many of cases where the persons are out of state also, some from Manipur, some from Meghalaya, some from Kerala or
From Manipur,
Bihar also.
from especially speaking from Manipur, they don't get response. Police do not respond to the summons. Trial court, I used to send warrants also. There's no report comes back. There is some states like Manipur and some like UP.
It's very difficult.
And Kerala, south, sometime it comes.
Hmm.
In this case, the mistake occurred because this hydroponic weed was the first time they got it. They thought it to be cannabis, ganja. But therefore they registered it as 20B because quantity is 3 kg only.
Otherwise,
forensic
it's
report
for hydrophonic.
Yeah.
Yes, this is the first time also I got this one. For
But when
hydrophonic.
the forensic report comes, that one chemical is there, drug is there, which makes it commercial.
That means 50 grams is the commercial quantity.
It's very expensive also.
Very expensive. This is the first case in here, not here, most probably. And I also quit the first case when I was a district judge in Kamrup. First case of cocaine, in fact. Otherwise, it's very cocaine
yeah, cocaine.
was there first. in
So
one party. It
is-
was there.
Here we had, DR has not inserted any cocaine. It
Hmm.
was one interception was there, one the Indonesian national.
Hmm.
He's still in custody, trial is going on.
Hmm.
They were suspected to be cocaine, but it's not cocaine.
Not
Initially,
cocaine.
it was found to be morphine as a, what you call the, like, refined form of morphine. It
Acha.
looked like cocaine.
Okay. And then I got a case for cocaine. Was a party for the was party going on wherein that cocaine was there. It was found. So otherwise, most of the cases are for heroin or brown sugar or whatever.
Well, this fellow from Indonesia, he brought 55 capsules ingested in his abdomen.
Acha.
So this were extracted in 3-phase manners. Initially, he gave out 50 grams.
Hmm.
Then we obtained the order from the learned CGM.
Hmm.
Then he said, no, why should I go to the court?
Hmm.
Then no, you have to take to hospital.
Hmm.
Then he said, I have the tendency.
Hmm.
You want to go to the washroom.
Hmm.
Then officers asked me that. I told them, take them to your office and to the room.
Hmm.
In that newspaper, he excreted 20 capsules there.
Oh.
Then he said, it's all done. I'm fine.
Ah.
The officers asked me that, no, you take to the hospital.
Ah.
Then he was taken to hospital.
Ah.
Hospital did in the front of doctor said, no, nothing is all out. Then doctor extracted 23 capsules there manually. So
What to do? নতুন ওলাই থাকে আর কি করি। But now we are dealing with the matters. I mean, most of the pattern criminals have already been out of the jail because of that grounds of arrest and all these things are
the
coming.
grounds of arrest, this Tufan Singh also causing problem. And this Mohanlal is also causing problem. Mohanlal has been taken care of by the recent judgment anyways.
Yes,
T2A.
Mohanlal is now, yes.
Now, but Tufan Singh is the main thing, my lord, because
But
these
one
people
stage, if you go by the Tufan Singh also, Tufan Singh is a case wherein, yes, conviction may not be there on the basis of the court statement, but during investigation, there
Yeah.
has to be some source. Otherwise, suppose if co-accused reveals something, on that basis only you have to carry out the other investigation part. So there has to be, I mean, base will be there for the statement of the co-accused. It may not be helpful in these things for conviction.
Nowadays,
But-
accused persons are highly equipped with the law. They know.
Yes.
Even in customs cases, my lord, they know that beyond 1 crore, if they bring anything, then
yes.
it will be non-bailable. So
Non-bailable,
they
yes.
bring all the consignment, gold, whatever it is, beyond 1 crore, it's 90 lakhs,
90 lakhs.
95 lakhs, 80 lakhs like that.
So that it may come under bailable offense.
Bailable.
Bailable. They are more smarter than us also.
Yes, yes.
Okay, Mr. Barrow.
I love that.